Okay, let's get started. And it's deja vu all over again. I'm going to, again, talk about the rationale for the class briefly, and then Paul will introduce the speakers and topic for today. So just to remind you, because we have many drop-ins, and also we put this up online, I want to give the rationale for the course. And as you know, as sentient beings, deep disagreement pervades our democracy. Right? We have serious debates over topics such as immigration, taxation, foreign policy, the Middle East crisis, selective education, abortion, and trans services for young people. As I've said, such disagreement is not by itself a cause for concern. We should expect that in a democratic society, a free society, reasonable people will disagree about many things for many reasons. Some of the deepest questions that we face are really hard to figure out. Questions of morality, religion, and value are hard to think through, and people come up with different answers to those questions, sometimes based on their different life experience, sometimes because they just see the world in a different way than somebody else, sometimes because the facts are really hard to pin down. And we've seen in this course that lots of times the factual questions are in dispute. Now, not all factual matters are really in dispute, so we want good evidence, but sometimes even with the best evidence, there's disagreement about how to weight different factors and how to interpret them. And even when we agree on the facts, we can disagree on the values and the trade-offs. And although disagreement is a fact of democracy, not all disagreement is productive. Lots of disagreement involves people trying to drown each other out, or not listening, not trying to learn or be open-minded or curious. And so what's very important in this class is that we seek to model evidence-based and value-inflected disagreement that's respectful and involves listening and learning even when there's no disagreement. And by the way, the aim isn't to get everybody to agree in some kumbaya moment. Disagreement is actually a good thing in many contexts. Not always, but often a good thing, because having plural perspectives is valuable. So we're not trying to get people to disagree, we're trying to get everybody to be open-minded and to learn. And with that, I'll turn it over to Paul, who will introduce today's speakers. Thanks.
So our guests today are a lawyer and a philosopher, and our moderators are a lawyer and philosopher as well. Rachel Rebouché is a native Texan. She's the G. Wally White Chair in Law at the University of Texas at Austin. She is a leading scholar in reproductive rights and health. She teaches courses on contracts, which she's going to teach tomorrow morning, family law, and healthcare law. She's the author or editor of 8 books, including 2 casebooks on contracts and family law, and the author of numerous journal articles. She serves as the faculty director of the Sissy Farenthold Reproductive Justice Defense Project. And before joining the Texas Law School faculty, she was dean at the law school at Temple University. Christopher Tollefsen is professor in the philosophy department at the University of South Carolina, where he also serves as interim executive director of the Center for American Civic Leadership and Public Discourse. This is, just an aside, this is one of increasing number of centers at universities that aim to create greater viewpoint diversity within the universities. His research and teaching center around ethics, particularly the area of natural law philosophy, popularly called the New Natural Law Theory. His work spans foundations of ethics, action theory, and various areas of practical ethics, including medical ethics, the ethics of lying and truth-telling, and beginning and ending of life. And portions of his most recent book, Killing and Christian Ethics, be out this year, were assigned for today's class. Our two speakers will discuss whether fetuses have moral and legal rights. And before Professor Tollefsen begins, let's put up the poll question. A simple and direct question with complicated answers, as you will begin to hear. So roughly 18% yes, 16% yes, 80 changes quickly. We'll average it at 20% yes.
Okay. We just went down to 17. I'm losing people already. It's a delight to be here. I'm really very grateful for the invitation. As Paul said, I'm the interim director of a Center for Civic Leadership and Public Discourse. The public discourse aspect of this really resonates with what you all are doing in this class, and I actually had to give a job talk last week as my position is becoming a permanent position, and I spent some time talking about your class because I think it's a great model for what we're trying to do. I'm going to address this question of whether we should treat the fetus as a person by asking 4 questions and giving answers and sort of the sketch of some thoughts about how those answers should go. And each of the questions falls into a kind of different category. So the first is a somewhat metaphysical question. It's the question, what are we? What are you and I? What are the folks that are up here? What are we essentially? And by essentially, I simply mean we're lots of different things that we could cease to be. Some of us are teachers, and some of us are students, and some of us are runners. Some of us are citizens of California, others are citizens of South Carolina, and we could cease to be all of these things, but we wouldn't thereby cease to exist. The question is, what is it that we are, that you and I are, such that if we ceased to be that, we would go out of existence, we would cease to be at all? And I think the answer to this is that you and I and everybody up here on stage are animals of a particular sort. We're human beings. We're individuals of a particular species. We're biological beings. And it occurred to me as I was walking here from my hotel that maybe this is a more controversial claim in a state in which people are thinking about the singularity and hoping to download in one form or another. But it seems to me that there's a good case to be made for saying that when I look at each of you and I see an animal organism sitting in each of these chairs, that I see the being that you are, right? And that each of us should be considered to be an animal, a human being from our beginning to our ending. That's a kind of metaphysical claim, right? But it does raise a biological claim that I suggested in the very last sentence, right? From our beginning to our end. What is our beginning? When do human beings begin? Right? When is it that each of us plausibly came into existence? And here is one of the areas in which I think there can be dispute about the facts. There are people who will argue about this, and we maybe can talk about some of the arguments that are made on both sides a little bit later in the conversation. But it seems to me that if you look at what contemporary embryology and developmental biology has to say, that a pretty uniform story is told. And that story is that unless you or I are a twin, in which case the story is a little bit more complicated, right? Then each of us came into existence as a single-celled zygote. Right? That zygote itself came into existence when a male gamete and a female gamete, right, both went out of existence. The male gamete, the sperm, entered the oocyte. Both ceased to exist as the things that they are, which is parts of their parental organisms, right? And in place of those two parts came a new, single, biologically whole individual human being. Right? That individual human being was possessed, right, internally of the genetic and epigenetic program that's necessary for that entity to be the agent, the executor of its own growth and development to the next stage, which in this case will be a 2-cell stage and then a 3-cell stage, right? But leading all the way through, right? Its fetal stage, or its embryonic stage, its fetal stage, its infant stage, right? And so on, right up to the point where right now there is an individual organism, a human being speaking to you, who's biologically continuous with that single-celled zygote that started out a number of years ago that I'm not going to actually say that number. It's higher than I'd like it to be right now. Okay? That one-celled zygote is not a part of the mother, right? It's biologically distinct from it, right? It depends upon the mother, of course, for its continued survival, and that's true of all of us at many stages of our life. Certainly at the infant stage, we also depend upon people around us, and many of us will go through periods of dependency late in life, right? But it is its own individual, unique entity, its own individual, unique human being, right? And that is an important biological claim about when the beings that we are, the human beings that we are, came into existence. So we have a metaphysical question and a biological question, and now I need to ask an ethical question, right? And the ethical question also is one on which there is intense disagreement. Maybe this is the one in which there is the most disagreement in the literature and in popular discussion, right? And the question is, which of the human beings that there are, which I take to include one-celled human beings and two-celled human beings and three-celled human beings, et cetera, as well as everybody here, right? Which of the human beings that there are deserve the most fundamental forms of rights, right, that everybody here takes themselves to enjoy? And again, we can distinguish between rights that are essential and fundamental and rights that are not. So if you're a student in this class, or at least in the version, I think there's a version that does some writing and maybe gets graded, right? Then you have rights to have your writing graded fairly and to have it returned to you in a timely way, right? Not everybody has those rights because not everybody is taking this class. If you're a citizen of the state, then you have rights to vote, but not everybody present in this room has those rights because not everybody is a citizen of this state. Right? There are a variety of rights that we have that come and go in accordance with our circumstances or our age or our status or our achievements. Right? If you are the top person at Stanford, the valedictorian, then perhaps you have the right to give an address at your commencement address, at your commencement. Right? Not everybody will have that right. But we would contrast that, I think, everybody here would contrast those sorts of rights with the sorts of rights that we think of as essential and fundamental, rights that we think that we all equally have, right, that are not a function of our circumstances or our location or our age, right, and rights that we think we all have equally, right? We don't have some of them a little bit more of these rights and some of them a little bit less, and rights that we don't think waver in the ways or we obtain them in gradual amounts, the way that some of the rights that we have in other contexts do. Right? And these would include what we think of as fundamental human rights: the right not to be tortured, the right not to be enslaved, right? The right not to be raped. I would include among this the right not to be intentionally killed. Now, if you've read some of the material that was distributed from my forthcoming book, that's a much stronger claim than many of the people who want to make claims about embryos and fetuses that I want to make, right? We could come back to that, right? But I'll just put that: the right not to be intentionally killed, right? Not to have one's death intended as an end or a means. But we could qualify it and say, right, not to be intentionally killed if one is not an aggressor or an attacker, if one wanted to make that claim. Right? Why think that, right? Why think that, or rather, why think that embryos, right, have those sorts of rights, as I do think? Well, it seems to me that the beings that have those rights, those essential and fundamental rights, right, should have them in virtue of a property that they possess essentially and fundamentally. Right? Not in virtue of a circumstance or a status or an achievement or an age or a location that they have. All of those things are variable, and yet the kinds of rights that I'm interested in are rights that are fundamental, essential, always equal, never variable. And so they should hang on a property that we possess in those ways. Right? They should hang on a property that we all possess equally, unlike the property of being a Stanford student, which some have and some don't. The only property that I think meets that standard is the property of being a human being. Our humanity is the only respect in which all of us here in this room are absolutely equal. None of us are more or less a human being than anybody else in this room is. Right? It's an essential property of us, as I suggested earlier. right? And so the most fundamental and essential rights that we have, it seems to me, should be predicated on the possession of that property, the property of our essential humanity, and not on some other property that comes and goes or comes in gradations or depends upon circumstances, age, or status, or achievement. So that's the third question. Which of us here and everywhere, right, which human beings possess the most essential and fundamental rights that we know of? And the answer to that I want to suggest is all human beings, right? The scope of the possessors of those rights is the scope of all of humanity. And that obviously includes, if I'm right in the claims that I've made just previously, that will include all single-cell zygotes, all embryos, all fetuses, and all infants, classes of human beings whose moral worth is often in dispute, right? But it seems to me, right, if I'm right in the three claims that I've just made, right, are properly to be understood as possessing the most fundamental human rights that we have. Now, the question that you have before you about fetal personhood, should embryos be treated as persons, right, could be understood as a moral question or as a legal question. And it seems to me that I've just suggested and sketched out the answer to the moral question. Morally speaking, I think the answer is yes, right? What are persons? I think they're the beings that possess our most fundamental rights. And so if all human beings possess those most fundamental rights, then we should consider them all persons. But I'll ask just one last question very quickly, right, which is to say, what are the most fundamental purposes of the political state? And it seems to me that the most fundamental purposes of the political state surely include keeping all human beings, right, not all citizens, but all human beings, protected against violations of the most essential and fundamental rights that human beings possess, the rights against torture, enslavement, and also including the right against being intentionally killed. And if that's a fundamental purpose of the political state, then it seems to me that we can talk not just about the moral rights that fetuses do have, but also about the legal rights that fetuses should have, and those rights would be the rights of persons. Thank you.
Thank you very much. Let me just get my notes set up here. I also want to thank our host. Thank you, Professors Brest and Satz, for inviting me to take part in this conversation, and thank you, Professor Tollefsen. It's been a pleasure to read your work and a pleasure just to get to know you today, but over email as well. So I am not a philosopher. I'm not a legal theorist. I'm a health law professor who teaches at a law school. And so I come to this question, is the fetus a person, from the perspective of how law should accord legal rights on a fetal person. And as a scholar who studies abortion law and practice, the medical care that over 1.14 million people received last year, almost 95% of them before 10 weeks of pregnancy, I hope to touch on more than law, but my focus will be on legal personhood, and in 5 themes. First, the distinction between human life and constitutional personhood. Second, the present biological reality that the fetus is part of the pregnant person's body. Third, the subjective and relational nature of fetal value. Fourth, the legal incoherence of personhood laws. And fifth, the significant harms of recognizing legal personhood. So first, human life and constitutional personhood as distinct concepts. I would argue that the anti-abortion movement has long conflated biological human life with constitutional personhood. But these are fundamentally different concepts. While living embryos and fetuses are both human and biologically alive, they grow, they change, they respond to stimuli, constitutional personhood has never fully overlapped with human life, even in the core of fundamental rights. So consider this: corporations are constitutional persons, yet they are neither human nor alive. Conversely, living human beings are not always considered constitutional persons, even in fundamental respects. Biology is not legally determinative. A so-called brain-dead individual remains biologically alive. Their heart beats, lungs respirate, digestive systems function, yet they no longer hold the exact same rights to bodily integrity, a fundamental and essential right, that non-brain-dead individuals do. The question for me is not whether that life has value or deserves dignity, it does, but rather how should law treat that life vis-a-vis other rights-bearing persons. As many scholars have articulated, person is a legal term of art that designates when an entity has rights, like the Supreme Court in the Roe v. Wade, a case that was reversed in 2022. The Canadian Supreme Court articulated why it rejected fetal personhood, describing it in this way. The issue is not one of biological status, nor indeed spiritual status, but legal status. For legal purposes, there are great differences between the unborn and born child, differences which raise a host of complexities. Protecting fetuses would radically impinge on the fundamental liberties of the mother, both as to lifestyle and how and as to where she chooses to live and be, end quote. So second, the second theme, the fetus as part of a pregnant person's body. The fetus is not a separate entity contained within the person's body. Rather, it is part of a product of her body. This view, of course, has deep historical, religious, and legal roots. In our legal system here in the United States, Justice Oliver Wendell Holmes is famous for writing in 1894 that a fetus was not a person able to sue in tort law because the unborn child was part of the mother at the time of the injury. This view has evolved, but routinely courts hold that injury to an unborn child is injury to the mother, at times exclusively. At present, the fetus exists fully, and I say at present because innovation and science that we can talk about in Q&A might change this. But at present, the fetus exists fully inside the internal environment of the pregnant person, is functionally and metabolically integrated into her through the umbilical cord and placenta, is dependent on her to maintain its internal environment and survive, is spatially continuous with her, and is immunologically tolerated by her body. The fetus is physically attached to and sustained by the pregnant person. Removing it would immediately destroy it at certain points of gestation, and this separation is irreversible. Once a baby is out, it does not go back in, ever. The fetus is also a product of the pregnant person's labor. The pregnant body must work over 9 months to construct not just a fetal body, but a new organ, the placenta. Sustaining the fetus requires pregnant people to increase their blood volume by 50%, straining the heart and metabolism, and literally reshaping the brain more dramatically than at any point in life, including puberty. On legal personhood, many have noted there is no prevailing conception in American legal thought of two rights holders contained in a single physical body. Instead, the body in American legal imagination is singular. Thus, either the pregnant person becomes merely the container for an individual rights holder, or the fetus is properly understood as a non-person body part of the pregnant person. We could change this status quo. And I'm not here to argue for the status quo necessarily, but a fluid conception of rights holders has its own complexities. Because third, fetal value is subjective and relational. It is not fixed. Qualitative research demonstrates that the value people attach to a pregnancy is subjective, variable, and fundamentally dependent on the pregnant person's relationship with the pregnancy, not on any inherent characteristic of the fetus. An unwanted pregnancy may be perceived as an invader, while an unwanted one may be felt as a loved child. Roughly 25% of women experiencing pregnancy loss report feeling that they just lost a pregnancy. They don't think of the child as a baby. They don't think of the fetus as a baby or a child. Conversely, some women who have elective abortions describe their fetus as a baby, feel grief in addition to relief. Emotional attachment to the fetus develops subjectively based on many factors. The pregnancy circumstances, gestational length, disclosure to others, the pregnant person's history, all of this is contextual. And tort law, for instance, in talking about legal personhood, recognizes this reality. When asked to value the loss of a potential child after pregnancy loss caused by negligence, courts look to the specific parent-child relationship and the subsequent emotional distress. No inherent or objective value is ascribed to miscarriage or the stillborn baby. It is individualized to the pregnant person. This subjective relational understanding of fetal value is dramatically different from a model that presumes life and personhood begin at conception or at fertilization. That is a totalizing view with profound consequences for our legal system, which is anything but uniform in its treatment of the unborn. So fourth, the legal incoherence of legal personhood laws. Current laws treating fetuses as persons in some contexts but not in others are fundamentally incoherent. Think of the contradictions. A state may ban abortion from conception while requiring viability for wrongful death claims. If the rationale for abortion ban is fetal personhood, why are wrongful death claims limited? Some jurisdictions allow survival actions for viable fetuses but have no corresponding criminal homicide or feticide statute, meaning the fetus is treated as a legal person in tort but not in criminal law. Georgia's Life Act, just to be a little bit more concrete, defines an unborn child as one at any stage of development who is carried in the womb. But an embryo in vitro at the same stage of development is not an unborn child. Georgia further recognizes fetuses for tax deductions, but not for child custody. Many states that ban abortion recognize exceptions for rape, incest, lethal fetal anomalies. Yet if abortion is killing a person, then a fetus created because of rape or incest or that has a severe anomaly is still a person. It is inconsistent to recognize unborn life as a legal person protected by the 14th Amendment of the Constitution in some contexts but not in others, when we do not make such contextual distinctions for those who have been born. Yet the answer, even for most pro-life people, isn't to strip abortion laws of all exceptions, life, health, the ones I named, largely for the reasons described here. The frozen embryo question is illustrative. Why would life begin at conception only when a fertilized egg is inside a pregnant person's body? If embryos are constitutional persons, there are over 1 million people being unconstitutionally detained in frozen cells throughout the United States, many of whom will be destroyed or donated to research. And this would call into question common fertility procedures like IVF, some forms of birth control, and medical research on embryonic stem cells. Is the answer to move toward uniform recognition of fetuses under the law to resolve this different treatment? I'd argue no, because fifth and finally, I think there are serious consequences of recognizing fetal personhood at law. The consequences of fetal personhood would be enormous, enacting a de facto national abortion ban, limits on birth control and fertility treatments, forced interventions on pregnancy and birth, and widespread criminalization of pregnant people who expose their fetuses to perceived risks. At the level of legal doctrine, the core problem is that every born human being is treated as a legal person under the 14th Amendment, regardless of context, as we heard. While born persons' rights may be limited in specific circumstances, think of incapacity or incarceration, these limits require constitutional justification. It would be difficult for a state to demonstrate a rational basis for conferring personhood rights on unborn life in some cases, but not all. And on a practical level, recognition of fetal personhood would have disparate impact on women. Empirical research demonstrates that women denied abortion care that they seek, that they want, face greater risks of economic difficulties, poverty, debt, higher chances of mental health issues, intimate partner violence, experience physical health complications such as life-threatening complications during delivery, and chronic pain. Any behavior during pregnancy that could threaten the fetus could become grounds for criminal or civil liability. How a woman drives, what she eats, what medical decisions she makes. Surrogacy contracts, which I've studied, clauses that pertain to pregnant people's behavior while a surrogate offer a pertinent experiment. Boilerplate language seeks to control the day-to-day decisions of surrogates while pregnant. Courts and lawyers uniformly agree that such provisions are unenforceable as a matter of law. As a contracts professor, we don't require specific performance of personal services, either at common law or as a constitutional matter. Women who miscarry could face criminal investigation, as we've already seen in states with aggressive fetal protection laws. Living wills could be restricted during pregnancy, and so-called brain-dead patients would be kept on life support to preserve fetal life without respect to their prior wishes. Personhood recognition has downstream consequences for treating future generations. One could imagine, for instance, discouraging clinical research on pregnant participants who consent willingly, voluntarily, undermining the validity of clinical research and making it harder to accurately diagnose and treat people. So in conclusion, the question before us, to my mind, is not whether fetuses are biologically alive or human. They are. The question is whether law requires treating a fetus as a rights-bearing person equivalent to those who have been born. Is there a world in which we might recognize such personhood as people's capacity to thrive and flourish, recognize such personhood at every point of life, before, during, at the end? I hope so. My personal belief, that is, until we meaningfully support the children, adults, and aged among us, reducing the deep inequalities and disparities that cause suffering and thwart their share in the common good, a focus on the fetus is misplaced. Thank you.
I expect that both Deborah and I have some questions along the way, but why don't the two of you engage in some give and take conversation before we intervene?
Sure. Okay. Is this thing on? So let me first say that as I emailed you, I really enjoyed reading the excerpts of your book, and I've started reading the rest of the manuscript because, and one of the things that I mentioned to you is I appreciate how accurate your descriptions are of the science of the beginning of life, and so I don't think that we disagree around those concepts, and I don't think that we disagree about questions around the common good. But I do wonder if we might disagree about what work your membership as a species, what work that does to relieve these concerns about over-inclusiveness, under-inclusiveness, and what you think as a policy matter we might gain in changing our concept of legal personhood in how we treat people in our contemporary society.
Great. Can everybody hear me? Great. Thank you, Rachel, and thank you for, it was just a great range of points that you made, and the essay that you sent around, I can't remember the authors.
Professors Naomi Kahn and Sonia Suter.
Right. That combined with your fourth and fifth point, I think, they're helpful for me. And so I want to make a couple of points about those sort of in responding to what you've just said. I think the essay that you sent around and the points that you've just made are helpful for providing a kind of map of the sorts of issues that somebody who has the position that I have need to face, right? And I'll just make a couple of quick points about that, about sort of what my aspiration is, my hope is with regard to this area, and then how this material, how these various problems, I think, could be maneuvered, or at least sketch out a way in which they could be maneuvered. But also just admit, right, you point out a huge range of issues, many of which go far beyond the questions of abortion and reproductive questions, to implicate larger social issues about justice and equality that I think we probably both agree, right, are massively in need of solution. So let me start with the very first point that you made about constitutional personhood, right? And this is not really an argument, but just a kind of sketch of how I think of this. I think of the history of this country in certain ways as a history of striving to match the country's founding aspiration, right, that all human beings would have constitutional and legal personhood, an aspiration, right, that the country, right, sorely missed out on reaching for, a couple of hundred years effectively, and to my mind has still not yet achieved. There's a big gap between that, between the range of beings that I think should be entitled to be thought of as persons and to be recognized as legal persons, and across the entire history of the U.S., who has actually been awarded, conferred upon that status. And I think that creates the kinds of problems that you're pointing to in part, right? When you have a historical regime, as it were, in which some or other class of human beings are not recognized as persons unjustly, right? And we can all, I'm sure everybody here will agree upon some instances of that having happened historically in this country, instances in which there were human beings who ought to have been recognized as persons who weren't. But when that goes on for a long period of time, then inevitably the social world is built and the legal world is built up around that injustice in ways that create contradictions and tensions and incentives to continue doing the same thing and not to change things because it would create all kinds of difficulties. And again, this is where I then get to your fourth and fifth points, because I acknowledge that a lot of what you point out are genuine difficulties with achieving that match between what I'm calling moral personhood and what you're thinking of as, and I'm thinking of as constitutional and legal person. And let me just mention one way that I think it's important to think about this. I don't want to hog the microphone, but I identified the right, the fundamental and essential right that I think all human beings have, is a right not to be intentionally killed, right? A right not to have it the case that if some other person takes your death as either their end, they want to bring it about because they're hostile to you or just because they want to kill somebody, right? Or as a means to some further end that they're pursuing, right? They want the inheritance, or you're in their way, or they don't like the look of you. There are a variety of different reasons that somebody might attempt to kill you. That's a pretty narrowly drawn right in certain respects, and it doesn't tell us a lot about the nature of the other protections that should be afforded of somebody's welfare, especially in circumstances which I admit are very unusual. The circumstance of an embryo, a fetus, being within a mother's womb, right? That creates all kinds of evidential issues. It creates all kinds of privacy issues, right? My children have, a full range of fundamental human rights, but it's certainly, it's also the case that my wife and I have privacy rights with regard to our home that make it not the case that the government can monitor our children or our lives with our children at every single moment. And the intimate relationship between a mother and an unborn child is, right, even more subject to privacy concerns that I think are going to work against the range of, say, over-surveillance that you're concerned about. But I think drawing that distinction in the first instance, that the right that I'm concerned is a right not to be intentionally killed, right, is part of the thread that I think you'd need to pull out in order to start solving some of the problems I think you're, absolutely legitimately pointing to.
I really appreciate that, and I appreciate the ethic in the work that seeks to achieve dignity and equality for all people despite historical discrimination and subjugation. And I think that's another point that we agree. Where I think I have trouble with including the fetus as a constitutional purpose is a few things. On the kind of macro level, I'm not sure that law is the intervention to achieve the kind of justice that you seek, that conferring a legal personhood would change necessarily the types of the ways in which we envision dignity or we confer dignity to each other. I think that law is part of the story, but it's a much broader conceptual, cultural, fundamental shift. And
again, what you've written a lot about and what I've mentioned, this idea of how we share and support the common good. So that's the kind of big picture point, and the finer point for me is even in distilling the fundamental right to a right not to be intentionally killed, you still have to do line drawing around intention, about what does it mean to intentionally kill. I noticed that when you write about rape exceptions, it's not intentional because the intent is to expel an invader. I think I might be I'm probably using the wrong terminology, but there is another intent rather than killing a life when there's a termination after rape. And that is a set of value choices that express intent in a particular way. And I don't know, I think that the project of coming to agreement about what is intentional and what is not, what is justifiable and what is not, what are side effects that we'd accept and what are side effects that we would not, those are complicated questions that in my goal in being broad-ranging was to express all the ways in which that could manifest. And so the question, I think, is to achieve what you have in mind, where would you start? And that I don't know. I as a lawyer, I get very focused on the here and now, and I think that the here and now is that we don't accord everyone equal rights in practice or at law. There's a lot of work to do, even on the front of privacy rights, that what you and I might take for granted in terms of a freedom from surveillance, many do not, particularly in pregnancy. And I think that what I'm mentioning is, the kind of afterlife of personhood arguments that then shape living people's experiences and rights in ways that are profoundly distance them from sharing in the common good. So I guess the follow-up question I have is, how do you cabin some of the more pernicious effects of personhood arguments for living people's experience of pregnancy and for their lives, from what you seek to achieve in promoting an ethic where we value life on a spectrum that includes, as I said, everyone on this spectrum of life, from, to your point, before birth, but to at the end of life.
Yeah, thank you. There's a lot there, a lot that I'd like to talk about. Let me just say one quick thing about the very first point that you made, and then I'm going to answer the question, the very direct question that you asked. And I agree that law can't do everything in this domain, right? And in fact, I think that there are real dangers, and this goes to the material that you sent in advance. There are real dangers in advancing the law further, much, much further than the culture is ready for it, right? There's the danger of a backlash that then makes things worse off for the group of human beings that I'm interested in protecting, right? And so I think although it is an imperfect situation legally, it seems to me that there is a very strong case for an incrementalist approach, right? But that incrementalist approach, while it shouldn't get too far out ahead of where people think the line should be drawn, nevertheless, I think does play an important role an important teaching role, right? And as long as it's the case that there are classes of human beings that are not protected against intentional killing, right, in the way that concerns me, right, then the law is teaching something about what it seems to me is the unequal nature of human beings, the unequal status of human beings across the board. And that seems to be a problem. I mean, it seems to me, again, that the aspiration of our legal system here in this country has been an aspiration that all human beings will be equally protected by the law, right? Now, that's a big aspiration, and I don't think that our grasp has yet reached where we have aspired to go. I think on the very last question that you asked, think we need to, just say two quick things. And one of them is very much in a bullet biting mode, because I think there are bullets that I need to bite on this. Right? I do think that any country, but especially ours, can do a much better job disincentivizing, right, the destruction of unborn children, and providing resources that would provide incentives for women who are having difficult pregnancies or who are finding a hard time to navigate a pregnancy and a job, or a pregnancy and an education, to be able to navigate, to make that navigation possible. I think we can do a lot more in providing resources in order that the costs of the legal regime that I envisage would be mitigated to some extent. But the bullet that I need to bite, I think, is the bullet that always needs to be bitten by any society that has tolerated, as I think ours has, a systematic form of injustice. And 80% of the people here disagree with me about this form of systematic injustice. But I'm sure that 100% of the people here can point to some aspect of our society, there's going to be a lot of overlap, where there is systematic injustice. And if not our society, then some other society. Right? And recognize that disentangling yourself from systematic injustice very often does come with real costs. Right? And those costs, if you are committed to the project of mitigating and eventually eliminating what you take to be a systematic injustice, right, those do eventually need to be borne. Right? And I think that I think you in some cases are pointing to genuine costs that would need to be acknowledged and borne by a society that was willing to say, as I hope that this one will eventually be, right, that all human beings are equally entitled to these fundamental forms of respect. And I'll just say what I think, one of the points that you think, I think absolutely rightly, is an incoherence in laws governing unborn human beings. I think it's an incoherence, and it would absolutely be a cost. Right? If all human beings are entitled to the sorts of protections that I'm advocating, right, then it's no life for a human being to be brought into existence in order to be frozen, right, in order to be able to stay cryopreserved up to the point at which your parents think that they may or may not have a use for you. That seems to me effectively a form of slavery. Right? You exist at their pleasure, for their purposes, right, and only insofar as you serve those purposes. And so the position that I'm advocating would in fact have radical consequences for assisted reproduction, for the IVF industry, which routinely puts hundreds of thousands of embryos into cryopreservation. And I think that would genuinely be a cost, and it's worth acknowledging that. I mean, it's worth my acknowledging that. Working out that incoherence in the direction that I think would be reasonable would make us, at a minimum, much more like some European countries in which it's illegal to fertilize more oocytes than you plan to implant. And that would be a major change in the way that we do business with assisted reproduction.
Let me try a question for you, Chris. There really are two different centers of discourse in the articles that you suggested we all read. And one which we've been focusing on is how law and policy incorporates ethical principles. And law always incorporates somebody's view of ethics, and with all of the complexities that Rachel has mentioned and that you acknowledge. But there's a fundamental point, which is what your book, Chris, is mainly about, which is not about how the ethical principles translate into law, but what the ethical principles themselves are. And you mentioned, and I wonder whether you can elaborate a bit in the chapters we read, views that say that human life, as we've described it, doesn't begin as early as the fertilized entity, that there are other requirements, whether in terms of consciousness, interests, agency, and the like. Could you talk some about that?
Yeah, sure. Thank you, Paul. I think there are two different kinds of arguments that track different parts of my opening remarks. So there are objections to the claim that I made that even the single-cell zygote or the early embryo is a human being, Right? There are some philosophers, I think mostly philosophers, I don't find this argument much made among biologists, some philosophers who think that the early embryo is insufficiently unified and insufficiently diversified to constitute a single organism. Right? If you thought, I talk a little bit about this in the material I think that was given to you to read, if you think that the early embryo is just a bunch of undifferentiated cells that are sort of held together by the zona pellucida as if held like a bunch of beer bottles that are being held together by a plastic bag, right? Then you're not going to think that it's a single organism. But in fact, there's quite a lot of activity that's going on between those cells. The cells are in communication with one another. They perform different tasks. Their descendant cells are performing different tasks that depend upon where the initial cells were located within the embryo. The situation is very complex. It's not at all like a bunch of undifferentiated biological mass that's just tossed into something and held there by an external barrier. The entity really functions like a single organism, and I think that's an important point at the sort of juncture of biology and the philosophy of biology. Right? It pursues its own biological ends. So there are objections to the claim that the early embryo is a human being, but then there's also a whole welter of moral objections, right? Some of which acknowledge straightforwardly. Peter Singer would say this, for instance. He would say, yes, the early embryo is a human being. What else could it possibly be? But no, the early embryo is not entitled to the same sorts of protections that a being who has interests or a being who has self-conscious interests or reflective interests or rational interests. Right? There is a gradation of status, even among living human beings, right, that makes it the case that at a certain point, right, you're entitled to much more moral consideration than you are when you fail to have either achieved these kinds of statuses, when you're not fully conscious or fully self-conscious, or when you don't have interests that range over an extended period of time, right? As clearly, in a certain sense, right, early embryos don't have. I think they do have interests, right? In the same, I think any living being has interests that are connected with its welfare, but an early embryo is certainly not self-conscious about those interests. I think the fundamental objection that I have to those positions, right, and it goes to our conversation too, because it reflects what I take to be the aspiration, the constitutional aspiration that this country has, is that they're all basically arbitrary at the point at which they divide human beings between those that are entitled to fundamental forms of moral respect and those that aren't. Right? My view has a very sharp dividing line. Right? The line is between what's a human being and what's not a human being, and that's a binary. Something's either a human being or it's not. But all of the other proposals come in gradations. Different human beings become conscious or self-conscious or feel pain, right, or have reflective desires at different stages in their life, and so different human beings would have moral rights at different stages. And all of those properties come in a graded spectrum, right? Some people have more and some people have less. Some people have more and some people have less at different times of their life. Some people have more and some people have less than other human beings. And so either those rights are going to vary and be graded in the same way that those properties are graded in individual human lives, or there's going to be arbitrary cutoffs and say, well, if you're underneath this threshold, you don't have these rights, and if you're over it, it does. And that seems to me ultimately to be a moral problem, right? That there's something fundamentally right about the aspiration to find the respect in which we share a basic equality and hinge our most important moral notions on that, right? Otherwise, at the end of the day, you are, and this is something that that I'm struck by in the article that you sent, you're conferring, right? You are making the decision about who and when human beings receive these entitlements, these rights, right? That puts us not at all in a position of equality. It puts some people in the position of being able to decide, right, whether others are going to be treated as having the same moral worth as the deciders are. And that seems to me, again, a kind of radical form of inequality.
And I will just respond briefly that, I think that this might be the crux of disagreement, and it's a disagreement perhaps about worldview and the orientation of how to solve these thorny problems, if they have solutions. But your definition of species membership itself has to rely on a certain type of line drawing. of who's in and who's out, who's alive and who's not. And, I found myself thinking about a future in which we could think about the afterlife of a person who passes, and how we might distill at some point what happens when someone dies, and is there something, and I could walk through a hypothetical, but you have to, again, draw lines about this membership based on what you know now and what you perceive now and what we understand now, both biologically, scientifically, morally, our lived experiences. And that's where I have a difficulty, because the question of line drawing to me cannot be separated from the question of cost. And some costs that you're willing to live with, I think I might not be willing to live with, because I think the costs are going to be disproportionately borne by some people. Some born people are going to be born by born people, and disproportionately, we can call those people pregnant people, and we might disproportionately call those people women. And that, I think, is something for me that I'm not sure that I can as easily separate those questions.
So let me push Paul's question a little more about the role of the state and the difference between private and public. So, Chris, as I understand it, a lot, you yourself say this is a kind of metaphysical question. Like, when does, what's a person? When does life rise to the level of having the full humanity and full human rights? There's no test we can give, no scientific test. It's a metaphysical question that people have some reasonable disagreement about. And so one question is, what's the justification for the state imposing one view about the right answer to this question on people who might reject that view? And reasonably, maybe you think it's not reasonable, but perhaps reasonably reject that view.
Yeah, that's an entirely fair question. And my answer is, in a weird way, going to be, I think, the mirror answer of Rachel's answer. But we just see, here's where I think we see things in a different way. I think the state has to do this because the stakes are so high, right? This is the fundamental question of who is included within, right, our moral community, insofar as that moral community finds ratification at the legal and political level, right? That seems to me, that's the starting point for any political question, any political society's deliberations. Who's included, who's in and who's out, right? And that's not even a question of citizenship, right? That just is a question of who do we offer protections to within our geographic boundaries. That's a prior question to the question of citizenship. So it's the first question. Who do we offer our protection to? The stakes are extremely high. I think that given that, right, there is a kind of general argument that I find plausible that one should be maximally inclusive rather than line drawing, right? I mean, that seems to me what is fundamentally liberal about the view that I have, right, is that it seeks to push the boundaries of inclusiveness out rather than draw them narrowly in. And I think that the metaphysical weight of this is pretty light. The biological weight is pretty heavy, but biology is a public science, right? I mean, I think if we go to the biologists and say, when did we begin, they're all going to give us the same answer. It's not a subject on which there's going to be a lot of disagreement.
Right, but we can't get from when do we begin to the answer about what rights.
No, that's
when do we have
sure.
rights,
but
when do we have constitutional status?
But that's true for all of us too, right? I mean, it's equally there. One could make a similar set of arguments that that are going to call into question whether we can do the line drawing even amongst adult human beings. Similar arguments have been made through history. And the stakes are too high, I think, to not do the line drawing. And then the question is, what's going to be the guiding star in drawing the line? Is it going to be cost, right? I mean, which is it's an important consideration. Or is it going to be, for want of a better word, right, inclusiveness, right? Is it going to be an effort to make sure that one does not unfairly put somebody outside the boundary that they should in fact belong in?
So can I ask two quick, so just a follow-up on that. That's not the only question the state faces, the question of boundary drawing. It's also the equality of women is also an important, so if you think about, like, what's the state's interest? And here I'll be Rawlsian, right? So Rawls thinks, due respect for life. That's a really important value. Making sure our democratic institutions exist over time, and ensuring the equality of women and men. And as the fetus develops, you might give more weight to the interest and to the standing of the fetus as opposed to at the very beginning. And that's the kind of, here's a compromise position where we do some line drawing, but we recognize competing and different political values and also pluralism, and we balance.
Right, that is a way to do it, certainly, right? It's a way that I resist because it seems to me of the foundational need to protect, right, the entirety of the class of beings that are worthy of protection from a particular kind of intended harm, right? But I completely agree that if one has made the decision to do that, right, then that brings upon one a lot of burdens of figuring out how to mitigate the costs that come with that, right? There is a strand of pro-life feminist literature, right, that argues that abortion has been very good for men, right, that it enables them to avoid a lot of responsibilities that they otherwise should be taking on. And that is clearly something that would need to be rectified in a world in which unborn human beings were given the legal protections that I think they should. That's both a cultural and a legal and an educational matter. It's very complicated, but that would be obviously part of the story of addressing some of this question of costs and equality.
So I have a question for Rachel.
Oh, good.
And I would just say, and it's interesting because the feminist literature on abortion is not pro-life, pro-choice. Actually, there's a very long history of feminist argumentation around abortion. Some of the earliest feminist writings made that point. Catherine McKinnon is in print on making just that point, that there could be a way in which abortion liberalization gave cover for sexual violence. The problem, I think, though, is not with that argument. The problem, I think, is the solution that you propose, which the disconnect, and as I mentioned cost, I don't mean to be just utilitarian. I'm not a cost minimizer, benefits maximizer. But for me, the problem is that, the membership category that you describe, and this is, I think, what Professor Satz was getting at, it doesn't necessarily ameliorate the consequences of what burdens pregnant people experience from unwanted pregnancies, say, after assault or rape or on any spectrum activity. I have a problem getting clear on what the legal solution will accomplish for those people who've experienced harm, and how legal personhood is going to address that harm. That we've both nodded toward a more kind of utopian ideal of where society doesn't tolerate that kind of imposition, burden, discrimination, dignity stripping. But that's where I find this kind of species membership drawing, and then what happens next to accord people the type of their share of the common good that we both can agree would be better than people suffering or shouldering harm disproportionately to their neighbors or to other populations. And that's, that conceptually I have a tough time figuring out then how policy and law particularly should intervene in what is a very messy, with a very messy set of tools to accord this very broad range of rights and interests.
So I have a last question for you, Rachel, and then we'll open it up to members of the class and auditors. Chris, if I'm right, if I understand you correctly, you would basically forbid in vitro fertilization because of the necessity of killing many fertilized embryos. And to you, Rachel, that compared to abortion, no doubt has unequal burdens. Would forbidding IVF also have unequal burdens, or are the burdens pretty equally distributed against the would-be parents?
I think it's a question both of where we are in fertility technology and a question of desire and intent. Forbidding IVF, of course, would have the consequence of depriving people who want to bring children into the world, who want to be parents, who want to be grandparents or form families. And that, I think, is, in essence, part of a noble consideration of trying to bring life into the world and to nurture and to care for it. And that policy would essentially say that who's in, people who can have children biologically, who's out, everybody else. And that is a type of line drawing that would be a consequence of forbidding IVF. The other point, I think, is one of technology, in that it would be hard to allow some technologies and not others, because a natural consequence of using IVF, even when you can try to line draw so there are some embryos that are used that will become children, so there's not intentional killing, selective reduction is commonplace in the experience of people who have embryos implanted and then shed embryos that do not attach and do not become pregnancies. And so there then lies my problem with what happens next. Is the person who had a selective reduction accused of murder? What are the legal consequences of that? That's a solution to a kind of middle ground I would try to find, but it would prove elusive. So you would end up with a ban that I think would deprive people of the type of benefits common good that, we're both advocating should characterize our social policies and our legal system.
Chris, it looked like you might want to have a last word on this.
No, I'd like to hear from.
Okay, so why don't we put up the poll question again? And meanwhile, there are 2 microphones, and I expect that some of you may have questions for Rachel and Chris.
Also attendance.
Oh, that's right. But first, I guess we do this. Thanks. Essentially, right. So from 17 to 19% or 20.
Take it.
All right. And then while people are lining up, can we please put the attendance QR code up there? And we can begin with you.
Thank you both so much for coming out and speaking to us. It's amazing that we can do this type of thing here at Stanford, and both of you are great professionals. Professor Tollefsen, one of my best friends, is a huge fan of yours, and we spent a lot of time actually discussing your work, so it's really awesome to see you here. So I will direct my question a little bit at you, since I have a little more previous experience. In your absolute view on lying, you have a similar position to the absolute view on killing, where no matter what, you shouldn't lie, it is morally wrong. But as we know, that isn't effective in our society, and that's not a means by which we can inform policy or create laws in this country. And I could take an even deeper framework on killing, where I say not just intentional killing, but all killing is immoral, and therefore we should live in a society with no risk, which, presents its own really interesting philosophical implications. But that's not the society we live in. Stanford has several alumni who've become billionaires, becoming defense contractors and doing that type of work. And the rest of our societal framework isn't really based on this idea of there should be no intentional killing. So why should that value or viewpoint inform just this specific part of our, political ideology, as opposed to the entirety of society? Like, why should we accept that most of our society can be governed by other values, but just the case of fetal personhood should fall under the intentional killing ideology?
Okay. Nice, very nice, thank you. And I think that, so maybe two-part answer to your question, which I like very much. And one is that I think there's lots of things that are wrong that shouldn't necessarily be a matter of state concern, right? For different possible reasons. One is that it would be too burdensome for the state to get involved, right? So yes, I've written a book, right, arguing that it's always wrong to lie. And occasionally people will say, oh, so you never lie yourself? No, that's not what I was. Partly I wrote the book because, lying, it's really hard not to lie. Right? If you write a book about it, then you sort of keep yourself honest in a certain way. But geez, if the state was going to police every possible opportunity that I had to tell an untruth, that would be extraordinarily intrusive. It's also not the case that, even though I think that every instance in which I've ever told a lie is wrong, that I think it's a matter of injustice, because sometimes I've told lies to people who didn't really deserve the truth, right? I still don't think I should have lied to them, right? But they were being nosy, or it wasn't really any of their business, and if I had figured out some way to dissemble, then that would have been a better thing. I shouldn't have lied to them, but they really had no right to the truth, and so it wasn't a matter of injustice. And so I think the state really only needs to get involved, and really only should get involved, A, when there's something that's a matter of injustice that's at stake, and B, where it's a matter of injustice of sufficient gravity that it is proportionate to the intrusiveness of having the state get involved in anything. And as I was sort of trying to articulate in my answer to Professor Satz, I think this question about who's in and who's out at the political level, right, really does rise to that level, right, such that if there's somebody who should be in but who's considered out, right, and is treated as if they're out, they're not given the same rights. That's like one of the worst forms of injustice that is possible. And so that's exactly what the state is there to prevent happening and aspires to not make itself complicit in the happening of. And it seems to me that the decision to count a certain group of human beings as not protected by the norm against intentional killing, right? Not causing harm, right? Because we, I think, inevitably cause harm in a wide variety of contexts, but intentional killing, right? That's the most radical form of exclusion and the most radical form of injustice, and it's something that the state really does need to get involved in a way that it doesn't have to get involved, every time, my wife asks me if I like her dress, right? I usually do, but it's possible that I've been not fully honest on one or two occasions. This is being taped. This is such a mistake on my part. Okay. Is that getting at your question?
Could I ask a quick follow-up? Would that be okay?
Yes, but maybe Rachel wants to answer
Okay.
the
Yes,
first
so
question.
I do, please don't forget your follow-up.
I won't.
But it strikes me that a question I had for you, just in response to this statement between lying and intentional killing, and forgive me if this was not in the excerpts that I read, but I'm not clear what the penalty should be. So if law has the role of redressing a radical injury, the worst injury that could be inflicted, what is law's solution, given that we live in a very carceral society? What's the penalty for intentional killing? Does it differ depending on what's the extreme and what's the not radical penalty for intentional killing?
I take it that it does differ, right? I mean, it differs depending upon circumstances, both objective and subjective. I think my preferred way of negotiating this for a variety of different reasons legally would be to focus almost entirely upon the physicians, right? Who I do think, right? I mean, if you're a physician who is performing abortions, you are clearly in the domain, I think, of intentional killing, right? Your job is to eliminate the unborn child, right? And you are not under the same forms of duress that a pregnant woman who is, experiencing a variety of difficulties is. It seems to me that's where the legal focus should be. What the details of that would look like, I don't have a well worked out answer, but it seems to me that is humane but effective in addressing like where I take to be the crux of the problem.
I have more to say about that.
I'm
but
sure
I don't
you
want to.
We have time.
Well, I just I'm curious though, because the wrong is so sweeping, both from the embryo in a petri dish to the embryo that's implanted in a person, that I find it, and the harm is so grave as a radical affront to moral personhood by the act of intentional killing, that it would be just physicians that the law would penalize as the deterrence for additional intentional killing. I don't see how that doesn't slide toward the pregnant person, the people who help pregnant people, industries, entities. I mean, we could agree on and disagree about but I don't. That doesn't seem to me to follow as clearly that it is the provider who law would target in order to enact the vision of eradicating intentional killing at all points of life.
I suspect that there's probably more than one way that one could reasonably draw legal boundaries to accomplish what I would want a just legal system to accomplish. And that is one that it seems to me is sensitive to, right, the historical context in which we live, in which women do rightly think of their lives as greatly disrupted by an unplanned pregnancy. And I think that creates a duress that is understandable, right, and that mitigates culpability, right? And those circumstances do not, it seems to me, apply in the same way to the physicians who offer to typically make money, right, from this procedure. And so focusing on them and on the procedure, right, seems to me a way of acknowledging, right, it's not going to be satisfactory, obviously, to everybody. It is a way of acknowledging different degrees of culpability that are unique to this particular context, and disincentivizing, right, a money-making industry that is predicated upon the destruction of unborn human beings.
And what I think is interesting, just a legal realist point and that's kind of the world in which I operate in, is that you might end up in the very world that we have, because when you start then calibrating penalties for some culpability that's more or less, the legal system is going to start to mirror kind of the exceptions and rules that we have around who should be punished more and who should be punished less. Quick aside, most abortion providers do not gain profit, but that's neither here nor there. But I do think it's interesting if we had the world in which you envisioned, but the way in which people were penalized was actually calibrated to a different set of theories and norms around culpability. Yeah, you might actually have much of what we already know in terms of the way in which we allow and disallow, excuse and non-excuse certain actions.
Maybe. I guess here's just a slight meta comment on all of this, right, which ties in with the nature of this particular course, right? I mean, I think I've said already, I don't think law can't do it all. right? And it can only do it in conjunction with a culture that is shaped in a particular way and that understands itself in a particular way. And that only comes about through what we're doing now, right? Through making arguments and hearing the objections to them, and then making the best case that you can and convincing 21% instead of 18, and then moving incrementally up. I mean, it's one of the great things about these initiatives, to my mind, is that it makes it the case for really almost the first time in the 20 or 30, I guess 30 years that I've been talking about these things, that the 80% that I'm talking to don't agree with me, right? I mean, for 30 years of my life, of my career, I've been invited to speak to people who in fact do agree with me, and very rarely to people who speak that don't. I think this is fantastic. And if you have follow-up questions, email me and we'll continue the conversation.
So let's do a quick follow-up, and then we have two people behind you.
I hate being pedantic, so I'll keep this quick and then sit down. I understand that the differentiation between the lying and the fetal personhood was the difficulty to police it. There's a lot of data, at least the stuff that I've seen, that abortion rates actually don't decrease. They either stay the same or decrease when abortion's legalized. So how would it be any more easy, I guess, to police than lying if the rates don't change?
Yeah, so this is, I think, a contested factual point. I think there are also, you could find people making the opposite case, that in fact there is a decline in the abortion rate where abortion is illegal and some other conditions are met. But clearly this is also going to be the case. This just goes back to the point that I just made, right? That the law on its own is going to be insufficient, right? The law does teach, but it needs to be supplemented by a lot of other good argumentation and good formation, as far as I'm concerned. So it just won't accomplish its ends in a vacuum.
Thank you, guys.
Thanks.
And I think we certainly agree about, I said something similar about law being inadequate in and of itself. And I love your point about contestation producing, some ideas in which we differ, but ideas in which we agree. But that last point, I do, there's the studies that have come out since Dobbs is the Supreme Court case that overturned Roe v. Wade in 2022. In each year after, the average number of abortions in this country has gone up. And we could talk about why, but it is the case that that's also true for the 12 states that ban abortion from conception. And there are many reasons why. I mean, I'm not disagreeing with you, but to that point, I do think it's worth putting out there that is not contested, that the average number has increased.
Quick question.
Hi. First of all, thank you both for being here. I think after hearing you speak, I can think about fetal personhood much more eloquently in my own mind. My question is directed towards Professor Tollefsen. So in your argument, you mentioned an exception based on cases of sexual violence, like rape. And you said that an abortion in these cases would be acceptable because it's not an intentional killing, it's like removing an invader from your body. Correct me if I'm wrong. But under this assumption, I mean, the zygote or the embryo, the person, isn't the one that's committing the crime. They didn't, of their own willingness or consent, insert themselves in their mother's body. The person that committed the crime was the rapist or the perpetrator. So under this assumption, isn't the embryo kind of just being killed as collateral damage? Aren't they an innocent person that's being murdered? And how do you reconcile this with your perspective?
So actually, thank you. That's very helpful for clarifying. So I do, in my book, I entertain, right, as being plausible, the possibility that abortions after rape are an instance in which the killing is not intended but is a side effect, right? A side effect of removing an unwanted being who, right, is seen as an extension of an aggressive act. Right? I also argue that the fact that something is a side effect doesn't automatically make it right. right? That clearly has to be the case, right? If I own a factory that has poisonous waste that needs to be dealt with, and I just dump it into the stream, right, and it goes downstream and poisons people downstream, and I just don't care, right? I'm not intentionally killing them or making them sick, right? But it's very unfair for me to shift all the burdens of my problem over onto other people who have nothing to do with me, so that I can receive the benefits of that. And I think that fairness is a central concern in thinking about what side effects it's reasonable or unreasonable to accept. And so two different thoughts about the particular case that you're talking about, the case of abortion after rape. Actually, I think that the point that you make, right, is an important point, and that it does suggest that, morally speaking, it is unfair to shift the burdens of what's happened onto an innocent human being, right? And so I think that morally, that's wrong. In my preferred, right, overall legal landscape, right, everybody would agree with that, right? And it would also be illegal, or wouldn't even need to be illegal, because everybody would agree with that. As a prudential matter governing how we pursue the laws, and I suggested this earlier, I think incrementalism is a necessity, right, that pro-lifers should pursue in order to actually be successful in preventing the deaths of unborn human beings, right? And that, for many people, right, as you said, right, that is a line too far, right, now and probably for the foreseeable future. And so it is a practical, political, legal compromise that I think has to be made. Right? It's not my preferred compromise, but compromises rarely are preferred. But it seems to me that it is required by a sound incrementalist pro-life strategy that these be distinguished from elective abortions and legally permitted, at least for now. Thanks.
Thank you.
Let me ask that each of you ask your questions now, and then our two guests will respond.
I just wanted to thank both of you for your very insightful contributions to this discussion. My question is directed towards Dr. Tollefsen, and bear with me because this may be a little bit wordy. So you argued that every human being from conception onward possesses equal moral status and therefore a right not to be intentionally killed, because the wrongness of killing does not depend on the victim's experience, just as a painless killing of a sleeping adult would still be murder. That suggests that moral worth rests on being a subject of a human life, not on capacities like consciousness or the ability to feel pain. But at the same time, many pro-life legal arguments and policies appeal to developmental milestones like neurological development or the capacity to feel pain when justifying legal protections at particular stages of pregnancy. So I'm trying to understand how that fits within your framework, because if moral status is not grounded in capacities, what role can these developmental milestones play in determining legal protection? And if they're treated as morally relevant, doesn't that imply that a capacity-based view of moral worth, which your account rejects? But if they're instead understood as political compromises, incremental steps meant to guide society away from injustice, how can a legal system that claims to be grounded in the equal dignity of all human beings justify knowingly granting only partial protection to some humans and not others without contradicting its own moral foundation?
So before you respond, let's hear the other question too.
Yeah, I also wanted to thank you guys for coming all the way out here and giving us insights into your argument. My question is about maternal mortality. It wasn't an issue that was talked about a lot. Maternal mortality is a relevant issue in this conversation, and it dictates often what a person is dictates the medical intervention that is performed. Based on your definition, Dr. Tollefsen, I wanted to ask, personhood begins at conception, and a single cell zygote is equal to born human beings. Therefore, we all deserve the same fundamental human rights. Now, in the case of when a mother's life is on the line as direct cause of her pregnancy, which life do you prioritize?
Okay, so I'll do that one, and then I'll go in reverse order. I do think that defending oneself against harm is, generally speaking, reasonable and permitted, right? Sometimes defending oneself against harm has itself harmful and sometimes lethal effects, right? And then, given this view that I have that it's always wrong to intend somebody harm or death to another, right? It always has to be the case, on my view, that the harm one does in preventing harm to oneself is itself a side effect, right? And this goes back to other things that we've just talked about, right? So if you are attacking me with the microphone, right, and I'm resisting you with my microphone, right, I'm using force to repel your attack, then any harm that comes to you, on my view, needs to be a side effect. That doesn't mean I can't foresee it, right? Sometimes very often I will absolutely foresee it. But it also needs to be fair, right? If you come after me with a plastic fork and I club you over the head with this microphone, that's probably disproportionate to the threat that I was under. In the kinds of cases that I think are very important and that I'm most interested philosophically, in which either both parties will die or the mother can do something with the physician's help to prevent death, but the child will die. In those kinds of cases, the child will die anyway, and so there's no shifting of burdens off onto somebody in order to benefit somebody else, right? It seems to me that the fairness requirement is met. And so if, right, on my view, right, the force or whatever instrumentality is being used in order to prevent the harm that's being done, such as removing, right, an ectopic embryo, right, from the woman's body, that will bring with it death, but the death is not part of what's intended, right? In these cases where either both will die or one will die, then it seems to me that can be reasonably undertaken, right? On the first question, which I think is a really, really good question, it's a really hard question. I think this is something that drives me crazy all the time, right? There is a lot of slippage between the political argument and the principled argument, so that it looks like people are arguing that when an embryo or a fetus can feel pain, right, that's a morally significant marker. And you're right, I absolutely don't think that is a morally significant marker when it comes to the question of who it's permissible to kill or not. Does it have a role in our political discourse to the extent that we're making incrementalist arguments? I'm just going to say I'm just not sure. I'm not sure if it does more harm than good, right? Because it does really blur this principled line and make it look like you're just accepting one of these various statuses that various philosophers have settled on as morally relevant, when in fact it's not morally relevant. And then if that's the case, then I think you're doing damage to the position that I'm trying to argue for. Thank you. It's something I need to think more about instead of just being agitated about.
Rachel, do you want to have a final word on this?
I just thank you for these questions. Thank you for this engagement. I often like being invited to where people disagree with me, so I appreciate your enthusiasm for that as well. And I would just say in response that I think your response to the last question recalls this problem of gradation, and that intention, membership, penalty, all of these things presuppose a set of value judgments about culpability and harm. And I think that you can't quite escape what that will look like as a set of rules and laws imposed on people. And so I'll just leave it there because, I'll leave it there.
So before we thank you, let me just say that Deborah and I have been constantly impressed by the questions from our students or whoever else may be asking them. And once again, we appreciate that a lot. But thank you both for a very, very rich conversation about this complex issue. Thank you.